Hi, everyone. Welcome to the St. John's Power Hour. I'm your host, Susan Damiani, and I am the Director of Gift Planning I'm sorry, someone just sent me a chat. I don't know what that just said. Did you read that, Sarah, by chance? Okay, sorry. I don't know. Sue, just check the chat. Sorry, I'm just saying I'm Director of Gift Planning at St. John's University. I also head up the McAllen Society, which is our legacy society. And I am so thrilled to have all of you join us. This session on financial and estate wellness is going to complete our month of wellness. And as we know, especially during this pandemic, that having, eating right and exercising, and, we talked about meditation, your mental state, all of that is really important for healthy living and to help us get through this pandemic. But I know for myself personally, if I owe money to somebody or, my credit card bill is coming up, I can get a sense sometimes of that anxiety level is like increasing when I know I owe something to somebody. And I know that's very a simplistic way of describing probably what we're going to talk about today. But I think that's why I added this into our month of wellness, because I think financial wellness is so important as well. And I think that's going to complete, the month of healthy living. So I'm really pleased that today I have the pleasure of introducing you two wonderful alumni of St. John's University. The first is Sara Finkelstein. Sara is not new to the Power Hours. She did one earlier in the year of the pandemic. And ironically, Sara and Paul, her husband, who is our production person, last year I had mentioned to Sara that I wanted to do webinars because I felt like I wanted to reach out to all the alumni and not just, some of the seminars that we would have in Manhasset or Rockville Center or Garden City. So Sara and Paul were so gracious and they volunteered. And they said, sure, we could do this from our home. We could do this for you. And I said, really? So I was like, great. And they said, yeah, this is platform Zoom. And that was like a foreign word, Zoom. Who ever heard of Zoom, right? None of us heard about Zoom. Well, obviously today, Zoom is, just a common word, in our vocabulary. But who knew last year that Sara and Paul actually prepped my office to be prepared to, conduct more of these virtual events for all of you. So you can thank Paul and Sara, because we really, and I really do thank you, because it has been, it was much easier for us to get up and running because we had a trial run with those 3 webinars, which were fantastic. But Sara is a graduate, 1987, like myself, from the College of Business Administration. She lives in Southeast Florida, so hello. I hope please bring our sunshine up our way because it's cold and snowy here today. She's a registered financial consultant, and she's also registered as a Social Security analyst, and she works for Signatory Advisory Group. And she also has written books. One of them, she's an author for Wisdom for Women, and that was last year, one of the talks that we had. But she's great with working with retirees and helping them with retirement planning. So thanks, Sara. I hope you're all settled in. You doing okay? Oh, you're on mute. How are you doing, Sara? You're okay.
Can you see my screen?
Yes, I can.
Okay, so you can hear me, you can see me.
Yes.
Perfect.
So you're okay, great.
Okay,
I'm going to introduce you to another wonderful alumni, and happens to be a good friend of mine. I'm very blessed to have him as a friend, Robert Moy. He graduated 1988 from the School of Law, St. John's School of Law, and he's a partner at Forchelli, Deegan, and Terrana in the tax, trust, estate, and corporate practice. I have to mention, but since I'm such a true Johnny, I have to tell everyone that you did go to Georgetown and you got your LLM from the Georgetown Law Center. We won't hold that against you, Rob. And Rob has always been a smarty pants. He has his BS at UPenn Wharton School of Business. So you're in really good hands here today. Can't wait for you to help us with our financial and estate wellness. And especially, I'm sure there'll be lots of questions now with the new president on board. What does that mean for all of us? What should we be preparing, or if any, or do we just sit tight and watch the markets and see what's happened? So I'm going to send it over to Sara. You going first? You're going first, yeah.
For inviting me. I appreciate the opportunity to be here and to share information. You do see my slide with the beach scene? Do you see my slide? Okay.
No.
No.
Yeah.
No, you don't? Can you hear me?
Yes, I can hear you, Sara. No problem.
Can you see the slide?
No, Sue.
Okay.
Are you controlling the slides for Sara?
Actually, I emailed the slides to Sue just for backup.
Oh, so you're sharing them, Sara?
Well, I emailed them to Sue.
Yeah, I would say let's just start, and then if Sue can maybe put them up as you go along, so this way we don't hold everybody up.
Okay, perfect.
Okay, thanks.
Okay. So imagine you're walking on the beach. You're feeling the warm sand beneath your feet. It's a beautiful day. The sun is shining. You smell the fresh air from the sea, from the ocean, and it just feels great. And this is retirement to some people. This is what some people want to have in retirement, to have the free time to do what they want to do, whether it's traveling all over the world, whether it's staying close to home with grandkids, or enjoying strolls along the beach. Whatever retirement means for you, it does require appropriate planning. And I put together a report, Financial Fitness Tips for 2021, which I would like to share with the audience. So rule number one, or fitness tip number one, is to pay yourself first. This was actually written about in a book as well. And it's very, very important because most Americans manage to pay their bills. They have to pay their bills. And sometimes they're not saving, meaning paying yourself. So it's important to treat paying yourself as a bill. And when you do treat it as a bill, you'll make sure to get it done. It's so very important to save at least 10% of your income. And if you could save more than that, well, then all the better. Tip number two is to take responsibility for your own financial well-being. The government, unfortunately, is not going to take care of us. And oftentimes, people delegate the responsibility of financial well-being to somebody else. And for women especially, because women end up, many women, I should say, end up alone at some point, whether through divorce or becoming widowed, we need to know what's going on. We need to be empowered to be there ahead of time instead of dealing with a crisis. So I encourage everybody, male and females, to get informed about your own financial fitness. Where is your money invested? How is it invested? What are the pros and cons of what you're doing? How will you reach your financial goals and your retirement goals? Take responsibility. It is up to you. And it's so important also, another tip is to establish an emergency fund. things that we don't anticipate. And so an emergency fund means that you have dollars set aside to deal with the unanticipated. And so instead of using a credit card to pay for emergencies, however big or small that emergency might be, by putting it on a credit card, you're going to be paying a ton of money in interest. And isn't it better to have that money in your pocket instead of making the credit card company rich? So it's so important to establish an emergency fund, and it has to be somewhere where you could reach it quickly. You have access to it. So it can't be tied up in an investment that you need to liquidate. Another tip is take advantage of free money. Now, what do I mean by free money? What I'm referring to is 401k employer match. The company that you're working for may offer an employer match. Maybe it's 3%, maybe it's 5%. That's like free money. And you should definitely take advantage of that free money in your retirement plan. Another great tip is live below your means. We are a society of instant gratification. We want what we want, and we want it now. And what that means oftentimes is putting purchases on credit cards. So the idea is if you live below your means, you will stay out of trouble. You will stay out of debt trouble. And very important is build your financial foundation before investing. Now, what do I mean? Financial foundation consists of insurance. For example, health insurance to make sure that you don't get hit with a huge medical bill. Long-term care insurance to make sure that as we get older, as you get older, you have a plan in place to take care of those expensive long-term care costs. And life insurance to protect your loved ones in the event of an untimely death. So that is the foundation of a financial plan before investing. Sometimes I see it's all about investing, and that's not a complete financial plan. Very importantly is to update your beneficiary forms, and I think I probably talked about this in the past. It's so important, and I want to share a story with you. There was an article in the New York Times back in 2005, and it was called The Pension Pickle. And it was a story about this couple, Anne and Bruce, who had gotten married later in life, but Anne had worked for the school system for years before she even met her husband, Bruce. And after 20 years of marriage, Anne unexpectedly passed away. And her husband, Bruce, was expecting to get her almost $1 million pension plan. And what happened was, because Anne had never updated her beneficiary forms at the school district, she just had, when she got the job, she put her mother, she put her sister, and she put her aunt as beneficiaries. And when she passed away, her mother had already been gone, and so had her aunt, but her sister was alive. And this case actually went to the Supreme Court, and the Supreme Court ruled in favor of the sister. So her sister got her whole pension account, almost $1 million, and her husband, Bruce, did not get a single dime. And of course, as you know, the sister was not willing to share any of it with her brother-in-law. So this is so very important. We often forget about those beneficiary forms, but things change over the years and over decades, and people get married, people have children. Please update your beneficiary forms. If nothing else from today, please make sure that you keep those forms up to date. Another tip is write down your goals and keep them visible and keep tweaking those goals to be able to reach them. So keep those in front of you as often as you can to remind yourself of your goals. And also another tip is to use and adhere to the Save Money formula. Now, what the Save Money formula does is it says that as we get older, more of our money needs to be safe and secure and guaranteed, and less of our money should be at risk. Because as we get older, we don't have as big a time horizon as we did when we were younger. So for example, a 70-year-old should keep about 70% of their portfolio in safe, guaranteed vehicles. What that means is that only about 30% of their portfolio can be at risk. And let's face it, everybody needs some money that's safe and guaranteed, and everybody needs some money that's positioned for growth. So adhere to the Save Money formula, and that will be a good part of your financial well-being. And as human beings, and myself included, I have in my lifetime procrastinated. It is so important to take action and eliminate procrastination, because procrastination prevents us from reaching our goals. Oftentimes, I know plenty of people that like to read books, they like to go to seminars, they like to go to webinars nowadays, and the saying goes that information is powerful. But I need to go a step further. Information is powerful when you implement what you learn to your benefit. Information by itself doesn't improve your situation. You have to take action. And there are threats to your carefree retirement. Healthcare costs. Most people know that when they turn 65, they qualify for Medicare, and Medicare is not free. The other part of cost in retirement is also long-term care. The statistics are that 70% of people over the age of 65 will need long-term care at some point. And if we haven't planned for it appropriately, we are then self-insuring that huge risk. And the cost of long-term care increase at a much higher rate than the rate of inflation. So long-term care is a conversation that I recommend that everybody have with their loved ones, children, parents, siblings. It's so very important. We're living longer, and the chances of us needing long-term care becomes greater the longer that we live. Another challenge in retirement is, will you have enough income to sustain yourself for a long retirement? It used to be that people retired at 65 and they might live another 10 or 15 years. But now it's not uncommon for people to live into their 90s and even beyond that. My husband's grandmother turned 98 last month, and her sister lived to be 106. So we really do need to plan for a longer lifespan. Another tip is inflation. Inflation erodes our purchasing power. And what I'd like to share for those of you that are not familiar with the rule of 72, I talk about the rule of 72 often because it's so simple and yet it is so powerful. The rule of 72 is used to determine how long it takes for your money to double. So for example, if your money, let's say, is growing at 10% divided into 72, that means that in 7.2 years, your money will double. By the same token, we can use the rule of 72 to figure out how many years before we need twice as much money to maintain our lifestyle. So if we believe the inflation rate is 4% divided into 72, in 18 years, we need twice as much money just to maintain the same lifestyle. And in 36 years, we need 4 times as much money. What is your plan to make sure that you can keep up with inflation? This is something that you should really be talking to your advisor. Another challenge to your carefree retirement is thinking that you're not going to live that long. This happens quite frequently. I hear it from seniors. I never thought I'd live so long. You cannot underestimate life expectancy anymore. And as a registered Social Security analyst, question that I get asked frequently is, when should I collect my Social Security benefits? Because people can collect as early as age 62 or as late as age 70. And the later that we collect it, the bigger check we get. If you collect it before your full retirement age, and your full retirement age is based on the year of your birth, if you collect it at full retirement age, you get 100% of what you are entitled to. If you collect it before, you get a discount. If you collect it after, you get what's called delayed retirement credit. So after your full retirement age, you get an extra 8% added to your benefit check. You delay for 4 years up until 70, you can get 132% of what you would otherwise get at your full retirement age. So this is very, very important. A lot of times people do not figure out exactly how much they're going to get in Social Security benefits over their lifetimes. So this is very important. We do planning for Social Security. And lastly, if anybody would like a printout of the financial fitness tips, I'd be happy to email them to you. We also have a monthly newsletter if anybody's interested in that. And that's it. I'm done.
Thanks, Sara.
Thank you.
So now we'll turn it over to Rob. And everyone, at the end of our discussion, you'll be able to ask your questions in the Q&A or in the chat box that is situated, I don't know, could be on the top or the bottom of your screen. So we'll turn it over to you now, Rob, and I'll turn my video off.
Thank you, Susan, and thank you,
You're
Sara.
welcome.
Thank you all. I'm happy to be here. And Susan said, I'm proud St. John's alum. I only went to Georgetown for a year, so I've never really taken a rooting interest in them. Unfortunately, the St. John's basketball team has been bad for many years, although they're looking pretty good this year so far. So I'm going to continue the planning portion, talking about estate planning or asset protection planning, whatever you want to call it. I like to make my clients think. It was an important part of financial wellness before, during, and after the pandemic. The pandemic has made a lot more people think about it, think about making sure they have adequate plans and adequate things in place. It's important to make sure that your will and your healthcare proxy and powers of attorney and trust and all your documents are in place, because if you don't have them in place, then there's nobody to speak on your behalf, and the government, as I'll mention shortly, the government will apply the law and appoint people or determine how your assets get passed under the law. So some of the most important objectives of any estate plan are to make sure that your assets are getting to the right people at the right time, that the value of your assets that Sara's helped you to invest and accumulate over the years, that they're protected and protected from creditors if you have a business. And people don't realize sometimes that the biggest creditor might be the government in terms of paying estate taxes and in terms of paying fees to get your estate and your affairs in order. The plan allows you to maintain control over how and when assets will be distributed, and maintaining flexibility to react to new laws, which is going to be important in the next few years as we have a new Congress and a new president in place, and everyone thinks that the laws will be changing in some way, shape, or form that affect your estate. And probably one of the things that a lot of my clients don't think about, if you have minor children, a properly drafted estate plan helps you protect your children by naming guardians in the will, and people frequently forget about that. I've seen, unfortunately, people that passed away without wills, and then the children are used as pawns as to who will get guardianship, because with guardianship comes control of the assets of the estate also. So that's a very, very important factor for people that have minor children. So what is available? What are the tools that are commonly used in estate planning? Well, before we get to that, I guess we'll talk about the ways that you can pass title to your assets. There's basically three ways that when you want assets getting to somebody when you're no longer here, you can determine who gets them. The first one, and Sara alluded to, and it's vitally important, things that have beneficiary designations, 401ks, IRAs, life insurance, trusts, annuities, things like that. Make sure, as Sara said, that your beneficiary designations are the ones that you want. And that goes by operation of law. When you're no longer here or at a certain period of time, your beneficiaries get those assets. The second way to pass title to assets is by having a co-owner. And in New York and in most states, you have joint tenancy with the right of survivorship, so that if you have property, whether it's real property, a deed in joint names, or whether it's a bank account in joint names, if one party passes away, it automatically goes to the survivor under joint tenancy with right of survivorship. In New York, if you're a married couple, they call it tenancy by the entireties, which means that the surviving spouse automatically gets the assets that are co-titled. There's another way to title property called tenancy in common, where you just own your percentage of whatever the assets are, whether it's real property or an account or any other sort of an asset. And that sometimes can cause problems. So you want to make sure that your assets are titled the way that you want them. I'm going through a contest or a disputed estate right now where they held property as tenants in common, and siblings, the person passed away without a spouse and without children, and the siblings are fighting over his share, which was held as a tenant in common with one other sibling, even though it was supposed to be held as joint tenants with right of survivorship. So things like that are very important as to how your assets are getting to the right people at the right time. And other than those two ways, the third way is by your last will and testament. So I always call the will the final say, the catch-all, however you want to put it. Everything else that doesn't have a beneficiary designation or that isn't passing by operation of law because it's titled accordingly goes into your will. If you don't have a will, then you die intestate. And in New York State, the law is that if you die intestate, half the assets go to the surviving spouse, half go to the children. Which some clients say, well, why do I need a will? That sounds fine to me. That's what I want to do anyway. Well, there are situations where there might be children from different marriages. There are situations where perhaps you want certain assets going to your spouse and other assets going to the kids. There might be situations where assets need to be given out at a certain time. So the will is your way, your last say of how your assets get distributed, when they get distributed. And as I alluded to earlier, very importantly, if you have minor children, who will take care of those minor children and who will get control of those assets? It also allows you to pick the person that will act as your executor to make sure that your affairs are being taken care of, that the assets are being distributed to the right people at the right time. If you have trusts inside your will, you get to pick your trustees, and those trustees perhaps will manage the assets on behalf of your children for a period of time into the future. I always tell my clients the executor has a short-term role, marshals all of the assets, make sure the will gets probated, make sure that the assets get to the retitled in the right people's names, to the beneficiaries. And then if there are trusts that are set up inside your will, the trustee has more of a long-term role. The trustee will manage those assets into the future for whatever period of time that you state in your will. So the will is the first basic estate document. Everyone should have one, whether or not you have children, whether you're married, unmarried. I always tell clients that if you don't have a will, it will almost 100% of the time, 99.9, because nothing's 100%, but it will cost your estate more money, because if you don't have a will and your estate goes into what's called intestacy, you have to spend a little bit more money to prove your heirs or your beneficiaries will have to spend a little bit more money to prove that they are the only living relatives and that they are entitled to inherit the property from your estate. In New York, there's a system set up where the court appoints lawyers like myself to act as guardians ad litem, and those guardians are paid a small fee out of the estate, and they do the due diligence to make sure that the people that claim to be relatives that are entitled to inherit from an estate where they died without a will, that they are in fact entitled to inherit and that they are in fact related to the decedent. So it's very important that you have the will, because the will is your last, it's your last will and testament. It's your last say. It's your determination. You're telling the court and you're telling everybody how you want your assets to be distributed, when you want them distributed, who's going to take care of those assets on your behalf. It's all things that I always tell clients. I make you think about things you might not necessarily want to think about, but it's important to think about it. And as I said, during the pandemic, a lot more clients who had been procrastinating or waiting or not worrying about it now started worrying about these things, and at the very least thinking about it. And many of them have started acting on them. Many of them did act on them. The other two basic documents, which again were highlighted the importance of them during the pandemic, are the Healthcare Proxy or the Living Will, where you appoint somebody to act to make all medical decisions for you. And it's any medical decision, not just the quote unquote pulling the plug decision, which a lot of clients perceive that's what the Healthcare Proxy is for. Well, the Healthcare Proxy is for all medical decisions. So if God forbid you're in the hospitalized, incapacitated, unable to speak for yourself, you're picking somebody to speak on your behalf and make those medical decisions for you. Similarly, a power of attorney is where you appoint somebody to act, to make legal and financial decisions if you're unable to do it yourself. And again, it's an important document to have if you're incapacitated, if you're unable to speak for yourself. In many instances, some of my clients use powers of attorney just for convenience. Two people don't want to show up for a closing, or they're out of state and they want to appoint somebody in state to appear at a closing for convenience purposes. A power of attorney is a really useful tool to have. There's a movement in New York right now. I think we will be getting a new power of attorney form sometime later this year, probably around June, sometime in the summer. So those are the three basic planning docs that everyone should have. Depending on whether or not you have an appropriate situation, I might recommend a trust. And there's many different types of trusts, over 130 different types of trusts the last time I checked. The ones that I most commonly draft are something, the first one is an irrevocable life insurance trust. So if you own life insurance and it's in your own name, when you're no longer here, the death benefit is included as part of your estate. If it's owned in this specific type of trust called an irrevocable life insurance trust or an ILIT, it can be taken out of your estate for estate tax purposes. Another commonly drafted trust I use is a credit shelter or a bypass trust for spouses. There are two exemptions that the U.S. government and state governments give you. Right now, the U.S. government gives you an exemption of roughly $11.58 million that you can leave to anybody without paying any estate taxes when you're no longer here. The New York state government gives you a $5.9 million exemption that you can leave to anybody and not pay any estate tax at the state level when you're no longer here. So with a proper plan, using two credits, one's called the unified credit, which is that number that I just gave you, and then there's something called the unlimited marital deduction. A married couple can leave at the federal level roughly $23 million, and at the state level roughly $12 million or $11.8 million. But it has to be a properly drawn up will or properly drawn up trust and a properly drawn up estate plan, and using a credit shelter trust is an important part of that plan. Another type of trust I commonly draw up is a charitable trust. I'm doing a couple of charitable trusts right now for people that are inclined, that want to leave assets to a charity when they're no longer here. And there's creative ways to do that. One that I'm working on in particular right now, one of the big benefits of charitable remainder trusts is that if you put an asset and this person's putting stock that's appreciated several $100,000 over the year, well, if he were to sell it in his own name, you have a capital gains tax you need to pay. By setting up a charitable trust, putting it into the trust and selling it in the name of the trust, there's no capital gains tax due. The way charitable trusts work is that for a certain period of time, you can receive income from the trust, but when you're no longer here, your charity, your favorite charity or charities, and it can be St. John's. I'll give a plug for my alma mater, or our alma mater, can be named as one of the charities that receives what's left in the trust when the grantor is no longer around. So under the appropriate circumstances, I will recommend the trust as part of an estate plan. But the one trust that I conspicuously left out, which a lot of clients come to me thinking that they need a revocable living trust, and a lot of times they don't. I probably talk more people out of doing revocable living trust than doing them. If there's a good reason to have them, then I will help them draft and have a revocable living trust. But if somebody comes to me and says, I want to do a revocable living trust, and the only purpose is to avoid probate, depending on their circumstances, that may not be a good enough reason to have that type of a trust. So those are the four basic documents that are part of any estate plan. There are other considerations to take into account, not the least of which is, as I mentioned earlier, we have a new administration, we have a new Congress, and we have a statute in place right now that says that the 11.58 unified credit is due to sunset in 2026. That means it's supposed to drop back down at some point in the future. And commentators think that the current administration, the current Congress will probably get around to dropping that number back at some point in the next 4 years also. So it's important to, if you have some estate tax implications in your estate is over 23 million combined, or 11.5 for an individual, it's important to start taking advantage of doing some planning and making sure you get some of those assets out of your estate in the short term, because from everything that I've read and the current statute, there will not be a clawback provision. That means that if they do drop the unified credit back down to 5 million or something significantly below the 11.5 million range, they won't come after you for assets that you've given away up to that point. It's not 100% certain, but that's the way it's currently structured. There isn't a clawback provision, and the commentators do not believe that there will be a clawback provision, even if they drop the unified credit down. In other developments in the future of estate planning, well, the pandemic has, especially in New York, where I've conducted probably between 12 and 15 remote will signings during the pandemic. It might be the wave of the future. The American Bar Association has come out and commented that the pandemic has illustrated that it's important to perhaps allow remote will signings and signings of your powers of attorney and healthcare proxies remotely, and allowing remote notarization. Governor Cuomo's executive orders, which has been extended throughout the duration of the pandemic, has allowed a lot of my clients and other people to execute their documents without being in person, without coming into the office. And there's a procedure that's set up, and it's worked very well. And a lot of people think that this is perhaps the future. You will no longer need a wet or an original signing in person with all the witnesses and the testator in the same room at the same time anymore. There's some discussion about having e-signatures be valid on wills in certain jurisdictions. I don't know that New York will ever get around to that, but certainly New York and some of the surrogates courts have now accepted e-filings, and in the past they'd never accepted e-filings, but they're even doing that now. So you can submit probate petitions and things like that by e-filing, followed up by an original in the mail. And they'll always need the original will for probate. So I think that is some of the future of estate planning that the pandemic has brought out. And I think the next 4 years will be interesting to see how the laws change. And as I said earlier, it's important that you have a plan in place that has some flexibility to take advantage whatever the laws are if and when they do change. And one example of that is a number of years ago when the unified credit was only $1 million, and it's since increased over the time. At one point it was 2 million, and then 3.5, and then 5 million, and now it's up at the 11.5 million. Well, somebody came to me with an old will that said I put $1 million in my credit shelter trust. Well, that language in and of itself did not allow them to take full advantage of the full unified credit up to the $11 million that it is now. So we made some changes, with some language and proper planning. You can have an estate plan that's flexible enough to take advantage of any new laws that may be coming. And that's all I have for now. I could continue to go on.
That's terrific. Well, we have some questions here, so I want to get to them before we close. The first question directed to Rob: what are the pros and cons of establishing a trust when you retire? I think you covered some of that, and I have to say I was surprised to hear an attorney say that you don't feel it's necessary to have the revocable, living trust, because I know that's always a popular vehicle. Jack Clark would be in agreement with you, one of our other St. John's lawyers, trust and estate lawyers. But what would be the pros and cons of establishing a trust?
Okay, well, there are different types of trust. Irrevocable, which means you can't change it, you can't take back the assets. It's a completed gift, which means that once you give it away, it's out of your estate. And those are the ones that save you estate taxes. The revocable living trust does not save you estate tax, and I think that's one of the big distinctions. As I mentioned earlier, revocable trusts are good under appropriate circumstances, and I'll use real examples. So in terms of retirement, or for some of my older clients, one in particular that I'll use as an example, she was getting to the point where she needed her children to manage her affairs. And so she put things into the revocable trust and appointed her daughters as the trustees to help pay her bills, to help take care of the house, to help. And she is a partner in several businesses, so they have the ability to do that as the trustees and help make sure that that their mother's affairs are being taken care of inside that trust. And so that's a good reason to have it. If you are establishing a trust after you retire and you're getting to the age where you don't feel like taking care of your own things anymore, or in this case, she kind of felt that she was slipping, and she wanted to make sure that her daughters took over for her as trustees and took care of her affairs. There are other situations where, rightly or wrongly, I have a number of Chinese clients, and the old school thinking was that the oldest son gets the lion's share. I had one client that had 4 children, and the oldest son was getting 80% of all of the assets, and the other 3 were splitting the other 20, which probably would cause some family disharmony. So in that case, they insisted, and I agreed, that perhaps setting up revocable trusts or any types of trust, one for each of the children, was probably better, because trusts are private agreements between you, the trustee, and the beneficiaries. Nobody else needs to know about it. In situations where I had another client, again using examples, and sometimes it's a self-fulfilling prophecy. She was certain that her son was going to get divorced and wanted to make sure that nothing was left to chance, that the daughter-in-law would get any of her assets. So she wanted a revocable trust. It wasn't for estate purposes. It was only to make sure that there was no chance that her daughter-in-law could get any of the assets from her estate. So we set up a revocable trust for her. And unfortunately, about 10 years later, her son did get divorced. I sometimes wonder whether or not, she helped push it that way, because she did not like her daughter. So there are circumstances where the revocable living trusts are useful tools to have as part of an overall estate plan. I think where they're overused, and where Professor Clark and I would agree, is that if you're only using it to avoid probate, then that's not a good reason to have a revocable trust.
And that's what he usually says. And also, isn't it used, I know in the circumstances like with my mom, just to protect her assets in case, God forbid, she would get ill, and it's a way to protect that. So if, like, God forbid, she had to go into a nursing home or something like that, they couldn't touch the assets if it was in the trust?
Well, that's a different type of trust. That would be for Medicaid planning, and a
Oh, okay.
revocable trust won't help with the Medicaid planning. You have to give it away in an irrevocable trust,
Oh, okay.
right? So that's a specific type of
Mm-hmm.
planning and type of trust where it's set up for that purpose. So you get the assets out, and the nursing home or the healthcare institution can't come after those assets.
Right, and I think the look back was extended, but I don't know if that's gonna stay the same. I think it was 5 years, now I think it's a 7-year look back.
Right, that's right.
Mhm.
And it depends on
Okay.
which jurisdiction you're in, because they look back and base it upon the expenses of whatever jurisdiction you live in.
Right. All right, thank you. There's another question we have. Given how well the market has done lately, should the traditional 70-30 rule for seniors be adjusted to, say, 80-20? Sara, you want to answer that one?
Sure. It really depends, because some people are more conservative, some people are more aggressive. So the 70-30 is a rule of thumb, but we always modify it for the particular clients.
Okay, thank you. We have another question. I have no siblings and not sure a close cousin will act as an executor. What is the option for assigning an executor? It's a good question.
Right. Yes. Yeah. And a lot of clients do have that holds up, and the procrastination and the delay is often caused because they don't know who to select as their executor or their trustee or as their guardians. I always say there's a kind of a chain: close relatives. If you don't have close relatives, then perhaps pick a close friend. Or the last resort is always an institution. An institution will definitively charge an executor commission or a trustee fee if you're going to appoint an institution to act as the executor or the trustee, but they will do it, and they will act if as the last resort you have no other close relatives or close friends. That's always an option. With relatives and friends, you can always deviate from the statutory commission rate, or frequently, or almost always, if it's a direct family member, we usually draft into the will that they're serving without a commission because they're going to be taking an inheritance already. Or sometimes for flexibility, you can build in that there is a commission, but it can be waived because a commission can be deducted as a cost of administration, and it might save the estate on taxes. So sometimes after having that discussion with clients, we're able to determine whether or not they want to include in the will or in the trust that they want commissions for the trustee or the executor.
Great, thank you. Question for Sara. This person has a diversified portfolio. Their only issue is where to keep a safety cash account since interest rates are so low.
Great question, but that's a hard question to answer. It's not something that we do in a vacuum. Whenever we help clients, we get a picture, an overall picture of their whole goals, because everybody's situation is different. Some people have children that they want to provide for. Some people have certain goals for their retirement. It's very hard to answer without knowing more about the individual and what they're trying to accomplish, because where we put money is dependent upon what it is we're trying to accomplish.
Well, maybe I can somehow connect both of you, and maybe you could talk offline.
Sure.
I have another question. It's directed to Rob. What impact will the new power of attorney have an existing POA, and will it have to be redone?
Thus far, we don't know for certain. I can base it upon the last change that was made. They made a change roughly 10 years ago to add a few items to the power of attorney and provide that certain signatures had to be on it. And at that time, the old power of attorney form was still valid. Now, as time has gone on, certain things, like if you're using a power of attorney to sell real estate. So you go into a closing and perhaps one of the spouses does not want to attend. Title companies and anything that needs to be recorded over the past few years, they've insisted upon a newly executed power of attorney using the current form, and they will not accept the old form anymore. So I'm sure there will be some guidance once they issue the new power of attorney form, and it probably will still allow the old forms to be valid for a period of time, if not indefinitely. But practically speaking, there will be some institutions like a title company and also some banks either use their own power form or they refuse to accept the old form as well. So practically speaking, if and when that change happens, I'll send out a notice to all of my clients and say you have the option. You can update it, you can change it, or you can wait till later at a time that you might need it. But I would probably recommend that if they can, especially if we're still doing things via video conference, that they update their powers of attorney.
Great. Well, I don't see that we have any more questions. We are right on time. Oh, okay, we got another one. Irrevocable trust. Wait, let me see what they just said. Okay, irrevocable trust regarding a special needs child. What type of assets can or should be placed into an irrevocable trust? If we place our house into the trust, what then happens if we decide that we want to sell the house?
Okay, well, I'll answer that second one first because, again, I think Sara mentioned earlier, it depends on your overall circumstances as to whether or not certain things are appropriate to put in an irrevocable trust. In general, whether it's for a special needs child or otherwise, if they're assets that you are going to miss, for lack of a better way of putting it, or that may or may not appreciate significantly in value over time, cash in a CD, for example. If somebody comes to me and only wants to put cash in to an irrevocable trust and no other assets, it may or may not be the best vehicle for doing that. You want to put assets in there that are going to appreciate over time because they're going to freeze the value of those assets. Specifically, as it deals with real estate, there are benefits and disadvantages of putting real estate into an irrevocable trust. For your primary residence, you get a capital gains tax exemption when you sell the property. So if two people own it, they each get $250,000 exemption on any profit when they sell it. If you put it into an irrevocable trust, that gain or that capital gains tax exemption could be lost. If you put it into an LLC, that capital gains tax exemption could be lost. So I don't generally recommend that a primary residence be put into an irrevocable trust. There are special types of trusts specifically for your primary residence, something called the QPR, the Qualified Personal Residence Trust, which has some benefits of helping save on estate taxes, but it's not an appropriate vehicle if you're ever planning on selling the house. As it relates to a special needs child, again, depending on what assets you're planning on leaving to the child or to take care of the child in the future, or to make sure that he or she qualifies for any governmental benefits, that would dictate what types of assets might go into the trust and in fact, whether or not you need any trust to begin with.
Thank you. And thank you for the person who asked that question, because I think that's an important one. I'm going to share just an example that we have at St. John's. Someone left a bequest to St. John's, and it looks like the distribution won't happen for quite some time because the family is upset that I think right before the person passed away, they revised their will, and the family was no longer in the will, and St. John's percentage rose to about 100%. So obviously the family was not too happy that St. John's was getting the money and they weren't receiving anything. And so now they claim that when the person, the donor, before they passed away and they revised this will, they were not of sound mind. And the attorney assures us that when he met with his client, that she was fine. But now they're contesting the will based on her mental health. How much of a case do they have? Like, what do you have to prove? And if the attorney had the discussion with the donor, does the attorney trump the family?
I mean, it's one of these things that is always a question of fact as to capacity, and that is a grounds for challenging a will, any type of a bequest, a trust, things like that. So, it's hard to say without knowing more of the facts. It is literally a question of fact, and the
Okay.
trier of fact will have to figure out whether the person had capacity or not.
Yeah, unfortunately, I do see this situation often where when family members, one or all of them, are taken out of the will, and, it makes them mad. They try to sometimes come up with reasons for ways to get back in, or somehow get a share of the distribution. So I think everything that Rob said today is really important. You really do have to protect yourself, and you have to protect those wishes of yours, of what you want to leave when you pass on. There's one last question for Sara about long-term care, and I would second that question. Do we really need long-term care? If I save money and all of that, do I really need to get long-term care insurance? And I know I'm getting older, so time is running out, because it gets more expensive as you get older.
Well, that question is an excellent question. I think a lot of people have that question in their mind. It's a matter of choice, really, because when the time comes that you need long-term care, are you going to use all of your retirement funds? Whatever's left of it at that point, will that be sufficient? Or will a loved one move in with you and take care of you? So it's a matter of cutting risks and making beneficial decisions, whatever is beneficial to the individual. We can't all look at something in the exact same way. I know for me, it was really important after I had to deal with long-term care for my mom, after I moved her down from New York to Florida. And I realized that it was something that was important to me. Especially since I don't have millions of dollars where I can afford to self-insure. So and realistically, I really don't want to use my plan. I hope to never use my plan, but I know statistically the chances are greater, and it gives me peace of mind that I have it.
Yeah, I think with everything that both you and Rob spoke about today, again, the wellness part, peace of mind. I think if you have a plan in place, I know so many people, I could share personal stories, like even with my uncle and even with my dad, not thinking about, the planning and future planning. And unfortunately, my uncle was diagnosed with cancer, and because he didn't have the plan, he was running around the last stage of his life worrying about his estate plans, where he should have been taking care of his health. But because he didn't have his estate in order, he had to deal with those details. So I always tell everyone, deal with it now while you're of sane mind and you're healthy. So like you said, you have peace of mind. And when you lower your anxiety, you lower your stress, you're going to stay healthy, right? So I think it's really, really important. Did we get another? I think I just saw something pass here. I think we're running out of time, but I want to make sure we get the questions in. I heard in the next 10 years, retirees' Social Security checks could go all to healthcare. What can a new retiree do to supplement their food, shelter, or clothing if all their Social Security goes to healthcare? Really? I didn't hear that.
Well, I think it's all about planning. That's what it boils down to, is planning, and also planning for the what-ifs that may happen to us.
Exactly. I don't think we have, let me just double check one more time. No, I think we're all out of questions and we're all at a time. Thank you, everyone. Sorry for the little hiccup with our technology in the beginning, but I hope you enjoyed this discussion. Rob, Sara, you were terrific. I hope you come back again, because I'm sure as we, go on into 2021, who knows, there'll be maybe some changes that we'll have to update everybody on. So thank you again. Have a great day, everybody.
Thank you. It's a pleasure.
And Sara, bring that sunshine up to New York. We need it.
I'll bottle it and send it down.
Great. I love it. Thank you. Yeah, sorry you missed that slide with the sunshine, because like I said, we really could have used it. Thanks again. Tell Paul I said hello.
Here.
Where's
Be well,
Katerina?
everyone.
Tell her to quick